This is dead.
Is the mic not working? Oh, he did not turn his on.
Gee,
You just got power on the side.
why you turn mine off?
You never talk. Not my fault.
Oh, sorry about that. No problem. I can mash the button. Push the button.
All right. All right. Good evening. My name is Kristen Ike. I'm the Code Enforcement Special Magistrate for the City of Deltona, and I'm calling the Special Magistrate hearing of September 24th, 2025 to order. The first thing on the agenda is roll call, so I will have all of the code compliance officers introduce themselves, please.
Mark Gibson, Code Compliance Supervisor.
Danny Ron, co-commercial.
Lisa Nadeau, Fire Inspector.
Jessica Cotterman, Hearing Clerk.
Todd Mead, Code Compliance Supervisor.
Renee Kearney, Code Compliance Administrative Supervisor.
There we go. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to proceed this evening. And I'm going to read this so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the city code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you've come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first instance. Any decision I make this evening will be put into a written order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by filing a written notice of appeal to the circuit court within 30 days of the execution of my order pursuant to Florida statutes section 162.11. The procedure of the hearing today will be governed by Chapter 162 Florida statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify. Tell me what you think I need to know about your case, present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number, and the city will proceed first. The city has the burden of proving that the code violation exists. Then you will be allowed to respond. For each case, I intend to omit the case file and the PowerPoint that will be shown for the case. And you should have received a copy of your case file when you came in this evening. If you did not receive that, please let me know when I call your case. But I do intend to admit the case file and PowerPoint unless a specific objection is received. I will take the cases in the order generally that you signed in, first come, first served, although I will take one case out of order this evening. As I understand, the officer is on duty out in the field this evening, so I will take his case first. And I do have a few cases to announce that have been withdrawn or continued. That would be for withdrawn cases, Fire 027 2025 271 Fort Smith Boulevard, as in compliance on 9/18/25. DEL 25-037B, a Massey case, 960 Shorecrest Avenue, also in compliance on 9/24/25. And I have two continued cases, DEL 25-086, 679 Vicksburg Street, which is going to be continued to October, and DEL 25-089, 1556 East Normandy Boulevard. Also, will that be continued to October? Yes, October. So if you are here for any of those four cases I just mentioned, you do not need to stay. We will not be hearing those cases this evening. All right, I will go ahead and swear in everyone who intends to testify today as a group, which includes the code inspectors, code enforcement officers. So if you're able, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say, "I do." I do. Thank you. The next on the agenda is the disclosure of ex parte communications. I have none to disclose, and so we will go ahead and get started with the cases. All right, first case on the agenda is DEL 25-087 A and B, 3182 Overdale Street.
Good evening, Your Honor. My name is Enrique Rios, and I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 25087 A and B. The City of Deltona versus Chase T. and Megan Carr. The property address is 3182 Overdale Street, Deltona, Florida 32738. The parcel ID is 813-042-030-150. The property is being brought before the special magistrate for more than one violation. These violations are as follows. Violation A, this is a violation of the City of Deltona Ordinance Section 18.5, adopting the latest edition of the Florida Building Code, Section 302.7, which states that accessory structures, including detached garages, fences, and walls, shall be maintained structurally sound and in good repair. Corrective action for said violation is you must repair and or install a gate or panel on the fence or remove the fence. The structure must meet all requirements of city ordinance and be approved on that final inspection. Violation B, this is a violation of City of Deltona Ordinance Section 6618E, which states that no vehicles may be parked or stored in the front yard forward of the edge of the principal dwelling except on an approved driveway or driveway extension. Corrective action for said violation is all vehicles parked in the front portion of the property must be on an approved driveway surface. Vehicles may also be parked on the side of the house, behind the front face, or in the rear yard. All vehicles must have current tag and be operable, or they must be stored in an enclosed garage. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. Your Honor, as it pertains to violation A, on August 9th, 2025, I arrived at the property in response to another violation and noticed the fence in disrepair. This violation specifically addresses the area of the fence on the front face of the home, which is missing a panel and not enclosed. It was explained to homeowners Chase and Megan Carr that a fence gate, panel, or other finishing piece needs to be installed, or the fence will need to be removed. A reinspection performed on August 16, 2025, found the property still in violation, and as a result, a notice of violation was posted on August 21st. A subsequent inspection on September 4th found the violation still unresolved. On September 11th, I made phone contact with Megan and advised her that a notice of hearing was posted to her property and again communicated the corrective actions. Megan explained her and Chase were acquiring a location for storing the vehicles and that materials were purchased and prepared for fixing the fence, which she expected to be completed by that weekend. Today's inspection reveals the property remains in violation and therefore is being brought to Magistrate. As it pertains to violation B, Your Honor, I arrived at the property on August 9th, 2025, in response to a complaint of large vehicles being parked around all sides of the property and found a work truck parked in the front yard. It was explained to homeowners, Chase and Megan Carr, that vehicles were only allowed on the side or rear of the home if they're not being parked on an approved driveway surface. A reinspection performed on August 16, 2025, found the property still in violation, and as a result, a notice of violation was posted on August 21st. A subsequent inspection on September 4th found the violation still unresolved. As previously stated, on September 11, 2025, I made phone contact with Megan and advised her that a notice of hearing was posted to her property and again communicated the corrective actions. The homeowner stated they were acquiring another location for storing the vehicles and that materials were purchased and prepared for fixing the fence, which she expected to be completed by that weekend. Today's inspection reveals the property remains in violation. Thus, said violations are being brought forth to Special Magistrate. The city would like to request 30 days for the property to come into compliance or a fine of $25 per day per violation to be imposed until such a time that the property owner notifies the city of compliance.
Thank you. Just a moment.
Thank you.
I have a question about the notice that was given in this case because the date that's given on the tracking is that I assume the notice of hearing was not mailed until September 17th. Is that correct?
Notice of hearing was not mailed until the 17th, is that correct?
Well, it doesn't tell me what it was that was sent, but the tracking sheet that's in the file says that it was sent on September 17th. Is that correct?
We have just a moment for that
Okay.
information.
What's that? It was mailed on the 12th?
I don't have a moment.
Why does it say September 17th? I'm concerned about having the requisite 10 days. Do you all see what I'm looking at? The tracking sheet says that it was arrived at the facility on September 17th.
So,
It could have been mailed out
Yeah.
on the 12th.
right. So
Well-
is the green card or the envelope in here? Sorry.
Nope, that's
There's a
right.
receipt.
Yeah, but I'm looking for one with a stamp on it.
There's no stamp.
Can we look at the case notes and see what that says? So that was affidavit of service.
This is, right,
We
it was
posted it,
posted.
Since basically
Yeah, are there any other?
Yeah.
that we do the 12th, I mean, the
So,
10 days.
notice of violation, notice of hearing. No. Assigned as a case. NOB, NOH, what's that? No?
Notice of hearing, no H.
So.
I don't see
has-
that.
It's just looking at, this says it was mailed out on the 12th.
I don't know, her and Todd were looking at something, I don't know Mark.
Give me just a moment. I
Thank you.
want to make sure that this is,
Yes, ma'am.
Usually there's a front page to this.
while we're looking
So
at that,
there's this-
oh, sorry.
There's this note here. Proceeded to post the notice of hearing and sent certified mail. But the number for the certified mail has not been entered in here, but that was on the 11th. So that would mean he gave the notice of hearing, which was the affidavit of service, which was the 11th. And it would have, she's probably right, it would have been mailed out on the 12th, but we did not put this into the case on the 11th.
Special Magistrate,
If I may-
I'd
Yes.
like to continue this case to next month.
Okay.
Yes.
All right, well, we can do that. I mean, the reason I'm questioning it, obviously, because it doesn't really make a lot of sense to me why it's saying that it wasn't, whatever you were mailing wasn't delivered to USPS until the 17th. So, I think that would be wise.
Yes,
to-
let's,
to
that way,
continue it.
yes. Let's
Yeah.
move forward. Yes,
All right.
let's continue this case to next month.
Let's do that. So we'll continue this one.
Rita,
I will say, I just wanted to, because you're a new officer, correct? I just wanted to say that the corrective action on violation B was nicely written. Yeah. All right. So we will continue that item. Okay, next case. All right, this is Fire 015-2025, a Massey case, 1698 Diane Terrace.
Good evening, Your Honor. For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-015-2025, the City of Deltona versus Harmony Clinic. The property address is 1698 Diane Terrace, Deltona, Florida 32725. Parcel ID is 8130-0336-0200. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing, notice of code of violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapters 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, the Florida edition of NFPA 1, Chapter 1.7.12.10, which states no construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. It was ruled on April 23, 2025, that the property owner was given 90 days to comply. The owner did not come into compliance with those 90 days and has been receiving a fine of $50 a day since August 27, 2025. As of today, the property has accrued a total fine of $1,450 over 29 days. That he is requesting that fines continue at $50 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
All right, so this violation D was for failure to obtain a permit for numerous interior alterations, correct?
Yes, ma'am.
And have any of those permits been submitted or obtained at this point?
Building 25-0079 was submitted on 8/26/25.
Okay, well, that was about a month ago.
Yes. And
So are you saying that that was not issued? What was,
it wasn't issued. It's a fire plan review was done on 9/18/2025 and is still undergoing building review.
I'm sorry, what did you say happened on 9/18?
9/18/2025, the fire plan review was done
Oh,
and is still undergoing building review.
okay, so you have given your review comments from fire,
Yes, ma'am.
okay? And are there corrections that need to be made still?
Yes.
To the plans?
Let's see.
Evening, Your Honor. I was the plan reviewer assigned to this permit. Yeah, there were numerous corrections that will need to be made. I talked to Chad Tate, building official. He's just looking into a few more things before he finalizes up his review comments.
Okay.
But his will also be a rejection for several reasons as well.
All right. Okay. So, right, okay, so then I'm just looking at the dates. So it was submitted on the 26th, which is a day before the time that was ordered for compliance.
Yes, ma'am.
All right. Sir, would you state your name and address for the record, please?
My name is Lester Carrero, and I'm at 1698 Diane Terrace in Deltona. And I did submit all my paperwork, everything already to the city. I guess I'm just waiting for results.
Yeah, understood. I mean, in order to come into compliance, you have to actually have the permits issued, not just submitted. Unfortunately, at this point, it appears that you haven't come into compliance as required. Yes?
So as I submit the permits or the paperwork, from there, the city can take usually how long to be able to come back with the permit or the approval?
Would you like to answer that?
Sam?
I can, yes, sir. It falls under
Florida Statute 533 dictates the maximum and minimum times we have for plan review. Without looking at it directly in front of me, I want to say a rough ballpark of 60 days. But that's why we normally give the 90 days to come into compliance, so you can
Okay,
get...
so I basically need
Can I
it then...
finish?
Go ahead.
Thank you.
Sorry.
That's why we give the 90 days, so you can get the permit in and then allow plan review staff ample time to conduct a review, your engineering team to do revisions, okay?
Okay. Sorry, there's a lot of activity going on in the audience, and sir, you're allowed to film, but I'm not sure why you're approaching near Ms. Nadeau. Can you back up a little bit, please? Thank you. All right. If you could get back towards the chairs, I would appreciate that. Thank you. All right. Anything else before I make the ruling, sir?
Everything is in the hands of my engineers at this point.
Yeah, understood. There are options for you, depending, you can always ask for a reduction later, but
Can I get more time, though? Just...
no, this is, I have made my ruling previously about how long I was allowing to come into compliance. That was 90 days, which is frankly generous. So I'm not going to change that. But to the extent that, you feel that it's appropriate, you may apply later, once you've come into compliance, for a reduction. Ultimately, it's the city commission's decision about whether to reduce the fine, but that's available to you.
Okay.
All right? Okay, I'm going to find that respondent in this case failed to correct the violation in the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm omitting the case file and the PowerPoint as exhibits and evidence, and I find the notices were properly given in this case. Thank you. Well, and I'll make clear for my ruling that we're talking only about violation D. Yeah, thank you.
Thank you.
There you go.
Oh, he was with the papers. Look on those papers.
Okay, okay. This is case DEL 25-054 A through C, Massey case, 916 Shorecrest Avenue.
You ready? I'm presenting this for Officer Bashir Turksey, who worked the case. I'm employed by the City of Deltona as a code compliance supervisor. This will be Massey case number DEL 25054 ABC. The City of Deltona versus Shammer R. Taylor. The property address is 916 Shorecrest Avenue, Deltona, Florida 32725. The parcel ID number is 813-011-410-180. The statutory requirements for the notification for this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what was observed on the day they were taken. It was ruled on 5/28 of 2025 that the property owner was given 90 days to comply. The owner did not come into compliance within those 90 days and has been receiving a fine of $150 a day since August 26th of 2025. As of today, the property has accrued a total fine of $4,350 over 29 days. The city is requesting that fines continue at $150 per day. And at 5 o'clock this evening, there's no record of any permits being submitted for any of the three. They're all three needing permits for A, B, and C. It's just nothing's on record of any application for a permit.
Okay, yes. I'm just trying to remind myself, so there was the shed there, and I'm looking at
So
picture 6, and then,
a shed, and there's a pergola structure, this concrete area, there's the pergola,
Okay,
and then the concrete is, so the blue concrete was permitted. The yellow areas that are behind the fence in the backyard, there was no permit pulled for that concrete. So there was those three things need a permit.
okay. Thank you. Can you state your name and address for the record for me?
Mike Beery, 916 Shorecrest Avenue, Deltona, Florida, 32725.
Thank you. What would you like to tell me about the
I'm
matter?
just giving you an update. It's been hell. I deal with contracting, obviously, but we've had 3 engineers, no call, no show. I have finally recently hired Rusty Nail Construction, who also has a state engineer that works for the state that has come out. So definitely progress now. So shortly we should have, and I got the original contractor that built the building to finally come off of the engineered plans for that building, which he didn't at first, even though they were paid for. So I have the plans for those to be submitted. I'm just waiting on the pergola finalized and be done from the engineer that finally came through for us. So it's costed a fortune. It's been tough, but I mean, we're finally making progress on it.
Okay. I appreciate that. I know it can be tough. We did, like the previous case, I mean, we did give 90 days, which I do think is a significant amount of time to come into compliance. So, you know, I think it's apparent that you haven't come into compliance within the time ordered. To the extent that you, again, feel appropriate, you can ask for a lien reduction later. But I think, you know, you haven't come into compliance within the time specified in the order. But I do
We've done everything we
appreciate.
could on our end. We're at the
Yeah.
hands of contractors and
Yeah.
engineers. So if it's too small of a job, they want nothing to do with. 2 of them just didn't even have the common courtesy to call back and say they didn't want it. So we wait, don't hear from them, hire a new one, wait, don't hear from them. Now we finally got. So, I mean, it is what it is.
All right. Anything else before I make the ruling?
No, we're good.
All
good.
right.
Oh, no.
Okay, I'm going to find that respondent, in this case, failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order, and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance, admitting the case file and the PowerPoint presentation into evidence, and I find the notices properly given in this case. Thank you. All right, this is Fire 040-2025 A and B, 2772 El Cam Boulevard. What is that number? 14.
Good evening, Your Honor. For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-040-2025. The City of Deltona versus Family Home Plaza Partnership. The property address is 2772 El Cam Boulevard, Suite D, Deltona, Florida, 32738. Parcel ID is 8130-7424-0310. This is a violation of City of Deltona's ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-16, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal. Violation A has been resolved prior to this hearing. Violation B, NFPA 1, Chapter 1.7.12.10, no construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards, and the applicable permits have been issued. Violation B for corrective action would be to obtain a permit for the installation of the magnetic locking system used at the front door or remove the magnetic locking system. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify that any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. The property owner's address on the notice of hearing was a Scrivener's error. The correct address was put, incorrect address was put on the notice of hearing. However, the correct address, the property owner's address, was on the NOV, the notice of violation. However, property owner was notified and is present. On February 5th, 2025, while conducting a follow-up fire inspection at this address, I observed a new electronic locking system installed on the front door of the business. The business owner was notified that a permit would be required for this installation and given a time frame to correct said violations. A copy of the fire inspector's inspection report was also emailed to the property owner. Subsequent re-inspections on April 22nd, 2025, July 2nd, 2025, August 4th, 2025, and August 21st, 2025, found the locking system still in place with no permit issued. Permit for electrical 25-0069 was applied for, on 9/12/25 and is currently under review and has yet to be issued. The city would like to request 90 days for the property owner to come into compliance with this violation or a fine of $50 per day until such time that the property owner has notified the city of compliance.
Okay, so on violation A, that is related to, it says a closet?
Yes, that's been cleared.
Oh, I'm sorry. All right, so violation A is in compliance.
Yes.
All right. And so we're talking about, I'm confused. Why would a permit be necessary for a magnetic locking system?
Has to make sure that if the property power is lost, that it automatically unlocks so anybody can get out without having to push a button to get out. It prevents people from coming in. Mm-hmm. And for the push button, it has to meet certain requirements for ADA building codes.
Okay. Is it magnetic? You said it's magnetic, but is there electric work that was done
To install it,
to
yes.
install it? Okay, yeah. All right. Okay, can you state your name and address for the record for me?
Yes, my name is Christina Serafine. I'm representing Family Home Plaza at 2772 Elkham Boulevard. The matter in question is our tenant, who's Jenny David. I do have one question, though. As the property owners, this notice was mailed out on 9/15, and we received it, I think, 2 days later. I know that some of the fire inspections are sent, but we were unaware that this was even happening until it went straight to a hearing as the building owners. So I don't know what the process should be.
So a notice of violation should have been mailed to you.
It was not.
Okay. Is that accurate from the city?
Yeah, I actually verified that it was used. I apologize on my laptop up in front of me, if you bear with me, I couldn't pull it up on my phone if you'd like. We do have email receipts for every single fire inspection report that we conduct in this location, including those pertaining to manual work emails to the property owner.
Okay, but the notice of violation was not sent to the property owner?
That's what I meant. I'm sorry. I meant, yeah, no, I knew that they had their fire inspection, but I didn't know that there was any violations until we got this notice, which was a big hearing.
There should be, for the next page, there should be notice of violation attached to that.
Right, what I meant was, right, what I meant.
Notice of violation was emailed to the property owner, Your Honor.
Okay. Well, notices of violation are not supposed to be sent by email.
No, it was mailed, Your Honor.
Well, it was mailed to whom?
Property owner. She's holding this now.
But it was not mailed before the notice of hearing was mailed, is the point.
Oh, correct.
Okay. Well, that is problematic because the statute provides that a notice of violation should be sent in the same manner as the notice of hearing. Because as she's saying, she didn't know that there was a notice of violation that even existed until she was ready to come to this hearing.
Ma'am,
Or well, you were ready to come to the hearing.
we would like
Yes.
to continue this case also for the next
Okay.
special magistrate.
Let's
Hearing.
do that. So, yes.
But, I mean, she is taking care of it.
Okay.
Everything's already been submitted to the city. I was just saying for, like, future.
Yeah.
It would be nice to, like, until we got to, like, the emergency status. I didn't know about it.
Right. Well, the proper procedure is that a notice of violation should be mailed to you, certified mail, and that should not happen only at a point when you are there, there's a notice of hearing that's accompanying it. And so, but they're asking to continue the matter. Hopefully, you won't have to come back if you're well on the way to compliance.
I do have a question.
Yeah, hopefully, yes.
So with the machine, or the locking system, I was notified when the fire inspector came that it needed a motion sensor. And so that's what I did put up, if you notice, that it needed. But today, I was notified that the button needs to be removed, but I was not told that at any other inspection. And a lot of times, they would come in, I'm working, so I'm a hairdresser, so I'm in the middle of doing people's hair. So it's really hard because they might be saying something or hand me something, and the paper is really unclear to someone who is like just a regular person. So today, I was just notified that the button needs to be moved, but it was never told me that before. If I would have known that, I would have moved it prior to, to make sure everything compliance. But I'm really unaware because I didn't have that information until this morning.
So the violation that we're talking about is for failing to obtain the permit? right?
Yeah.
And I presume that what we're talking about is then basically review comments perhaps on the permit? Is that what is leading to this confusion? Do you know, Mr. Schaller?
I was going to say, I did look this morning, and we do have a permit application on file.
Mm-hmm.
Pretty simple permits.
Mhm.
They just submit the spec sheet for the equipment. We come test all the fail safes of it. Do you know when you submitted it?
Well, there was a little bit of issue. My electrician tried to submit it the December 17th. And so there were some issues with Deltona. He's not in Deltona, so there was some paperwork. So it got kicked back twice. And so then it got resubmitted. And I guess when I talked to Chad yesterday, he said that there was some paperwork missing, so it had to be resubmitted. So I guess it was done last Wednesday, though, is the original. It was 2 weeks ago and then the last Wednesday, from my understanding.
So it just sounds like we're just waiting.
Yeah, it's a waiting game, yeah.
Okay. I'll look into that today. Not today. I'll
And-
look into that morning for you.
Okay.
How about that?
Yeah, and can you let me know about the button, exactly what I need to do with it? Because I'm a little confused by that. Like I said, I just found out this morning, so I just want to make sure everything's in compliance.
Hey, Mr. Schaller, is your mic on? Yeah.
It is now.
Thank you. Okay, so from my perspective, in order for you hopefully not to have to come back here.
We are not
you have to
coming back, I promise.
obtain the permit, and there may be review comments from the city about, I don't know, moving I'm not sure about moving the button. Those are technical issues beyond my, my purview. But what I'm saying is, in order to get the permit, you need to comply with whatever the comments are in order to get the permit issued and come into compliance with the code. So just work with Mr. Schaller, hopefully, and get that resolved one way or another. Okay?
Thank
All
you.
right. Thank you. All right, so violation B there is continued to next month. All right, the next case is DEL 25-088, 682 Deltona Boulevard. Good evening.
Oh, there it is. My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 25088, City of Deltona versus Multilink Entertainment LLC. Property address is 682 Deltona Boulevard, Deltona, Florida 32725. Parcel ID is 803-605-010-030. This is a violation of the City of Deltona Ordinance Section 38-114, which states that storage of building materials, commercial and industrial equipment, materials, objects, or waste relating to commercial or industrial uses, or any equipment, materials, or objects that are not incidental to a residential use shall be prohibited. Furniture inside a covered structure. In addition, storage of materials relating to residential use, children's play toys, firewood, brush logs, or any other material intended to be used in fireplaces or other permitted burning facilities shall be permitted only in the rear yard next to the rear wall of the home. Corrective action for said violation is to remove the outdoor storage from the property. Statutory requirements for notification of this hearing have been met by notice of hearing and notice of code violation was sent and certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they was taken. This case was started on July 22nd, 2025 by my supervisor and manager while viewing properties on Deltona Boulevard. Debris was observed on the property. On July 28th, I conducted a site visit, spoke with the property owner. He stated he was doing work at the property and the debris was from the work that was done. He informed me debris will be gone within 2 weeks. On August 11th, I posted an abatement notice. On August 29th, I was directed to take the case to magistrate. Notice of hearing and notice of violation was posted at the property on September 9th, and as of today, the property remains in violation. The city would like to request 14 days for the property to come into compliance or a fine of $25 per day for this violation to be imposed until such a time the property owner notifies the city of compliance.
All right, so can you just explain what I'm looking at in the photo? It's just hard to see.
So there's materials back there with like tarp covering over it that I'm guessing like building materials and stuff that's not designed to be outside.
It's building materials?
Yes.
Okay. And then, and I'm sorry, in the previous photo, okay, that's, all right.
So that's from the right away and I zoomed in.
This one, no, stop, the previous one. This one, B3. So that one also has the tarp on it?
Yes, ma'am.
Okay. All right. Sir, can you state your name and address for the record?
Delphil Blackburn. I'm here representing 682 Deltona Boulevard, Deltona, Florida 32725.
All right. Are you the owners of multi-link payment?
Yeah, I'm the owner of the
Okay,
property, ma'am.
all right. What would you like to tell me about the case?
Okay, first, can you do me a favor? Can you Google the address, please? So we can show up on the screen, please.
Well, it's not my responsibility to provide evidence in the matter. That's up to the city, whether you'll Google it and show it on the,
Okay, I just wanted to make a quick, my case, like, pretty firm, if that's okay. If somebody could Google.
You
just
want like Google Earth?
No, you just Google it. The previous picture will come up to show what the property looked like before.
Oh, okay.
is that, are you all working on bringing it up or no? Yes? Okay.
Yeah, this is the Google. This is what the building looked like before, Your Honor.
Okay,
Was
I
it-
can't see that, so no,
Okay.
he'll bring it.
Okay, yeah, that was it.
This is April 2020.
April 2020, yeah. But that's a pretty picture on there. It was the ugliest building on the block. I started to remodel in the building. When you're doing construction, ma'am, you're gonna have debris. You're gonna have tools. You're gonna have it's gonna look like a mess, right? So yes, he did come, and I agree that there was debris there. I cleaned it up. That I think that loose wood or materials that wasn't being used, garbage. I disposed it myself. I pulled the permit for the building in January. They're short enough labor. The contractor couldn't get anyone that was documented to work. Here's my permit. I pulled it, and I didn't get the construction start till late July. He came while they were working on it. A week later, right after they finished it. It wasn't painted. It wasn't sealed. Nothing was up. It wasn't even signed off finally yet, but I cleaned it up. Those are materials. The work is not done yet. If you look on the other side, there is a scaffolding where the guy come in, he's using the caulking to caulk where on the edge. See, those are tape it off so the soffit won't get messed up by the paint. I'm very particular about my buildings because I spend money for it, ma'am. And I'm making sure that it's sealed properly and everything has been done. I understand he's doing his job, but I think they pressured me. Before the building was being remodeled, I had no complaints from the city. Once I started it, they tell me about the sign. It's been torn down. I tore it down, comply on that. I got that done. Anything they complain on, I fixed it. So I don't know. I mean, I don't know if they want me to pick up the guy's tool and dispose of it. The job is not done yet, ma'am. It's still been worked. It's still a construction site. So I don't know what the city wants me to do. Those are tarps. Those are materials. They're covered, so water don't wet them.
Well, I mean, the city code clearly prohibits the storing of building materials on residential property.
That's not residential. That's commercial.
it's commercial property?
Yes, it is commercial property, ma'am.
I think it's zoned for both. I'm not 100% on
It is a mixed zoning.
Mixed
It
use.
is mixed use commercial property. So I had through a commercial contractor to get work done.
Is this a resident, is it a single-family home?
No, ma'am. It's a commercial property. It's a
You're not
office
answering my
building.
question. Is it a single-family home? Is that what it's being used for?
No, it's an office. I'm gonna rent it out, so I'm remodeling before I put it on the market.
You're renting it out as an office?
That's what it is, ma'am. It's zoned a commercial building.
All right. So,
All of that is not visible from the street. I make sure of that. I told the guys where to put their materials and their tools and their equipment, so it wouldn't be messy. They had to go next door to actually take these pictures. If you can see,
yeah.
there's a lump of sand. That's sand right there that's left over from where they were doing the stucco. This not visible from the street, ma'am.
Well,
The debris that I picked up was visible from the street because if you looked at the building, it was wood. So when they tore it down to put the new face to the building, it was messy, I must admit. I cleaned it up. He came, we had dialect, and I corrected that.
all right, for the city, can you respond to that, that statement about that, this is a commercial property? If I'm reading the code section that's cited, this relates to residential uses.
If I may add something, it could confuse. It is zoned a commercial property, but if you look at the permit here, when the contractor pulled the permit, he pulled it at residential, so we had to change it over commercial. So on I guess the information that the city has, it could be like misleading. I don't know. I'm just adding that on his behalf because that's the problem that we had. So there was on the lath, when we lathe it, because some part of it is wood, we had a residential inspector came out and he couldn't sign off on it. We had to have a commercial inspector come out to sign off on the lath. So maybe on the city it's not documented correctly.
Mr. Ron?
We can't answer that in a moment. All we want is the property being cleaned up. If it's stuff that's stored outside, bring it into the building, not outside, to make it look presentable. You did clean up some of the debris, which we appreciate, but the rest of the stuff, we would want you to bring it inside the building.
Those materials, why should I bring materials that's going to be outside, inside? I understand what you're saying, but the city has to correct this because it's showing up as residential. It has to be corrected as commercial. It has to be documented properly. And I do understand what you're saying. It's going to be cleaned up. I'm not going to spend all this money to get it done and the property is not cleaned up before it's rented out. So I do understand, but I think it needs to be documented properly. Because I went through hell getting the permit because we had to keep redoing stuff. So, I mean, I understand, and if I need to go and file something to the city, I'm more than willing to do that.
Well, I think at this point, what I'll say is the section that's cited here is 38-114,
Yes, ma'am.
which relates to residential uses. So I don't know how I can find a violation of that section. That being said, sir, there may be other sections of the code that would require even a commercial property to store your materials inside. I can't comment on that, but what I'm saying is I'm going to dismiss this case, but that doesn't prohibit the city from bringing a different case if there's another section that applies. And so I encourage you to try to work with the code enforcement officers about bringing the materials inside, because you may have some other violation that's occurring.
Okay, thank you. And for the record, the contractor told me within about 3 weeks, it should be all cleaned up and turned over to me.
All right, well, again, I encourage you to stay in contact with Mr. Ron or Mr. Scott, and keep them informed. And again, hopefully you all can come to a resolution of this without you having to come back here again. I hope that's the case.
Okay.
All right?
Thank you for your time.
I'm going to dismiss case 25-088.
Thank you, ma'am.
Thank you, ma'am.
All right, next case is DEL 25-090, A through C, 1018 Giovanni Street.
Good evening. My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This would be case number DEL 25090A, B, and C. City of Deltona versus Jose Johan Pierre.
Pereira.
Thank you, sir. Alvarez. The property address is 1018 Giovanni Street, Deltona, Florida 32725. Parcel ID is 813-007-450-010. This property is being brought before the special magistrate for more than one violation. These violations are as follows. Violation A, City of Deltona versus, I'm sorry. This is a violation of City of Deltona Ordinance Section 38113A, which states it shall be the responsibility of every owner, agent, tenant of improved property in the city to at all times maintain those right-of-ways most nearly abutting their property. These responsibilities shall include removing litter, debris, and cutting grass and weeds to maintain a neat and trim appearance. Corrective of SAT violation is to, where the grass is worn out, replace with new sod or seed. Violation B, this is a violation of City of Deltona Ordinance Section 5831A, which states that consent required pursuant to the police power of the city. The city commission determines in the interest of the health, safety, and welfare of its citizens that the use of any city right-of-way, including appendages, and the use of any public lands under the authority of the city commission, except for their intended purpose without prior written consent of the city, shall be prohibited. Corrective action for said violation is to cease from driving through the right-of-way. Violation C, this is a violation of City of Deltona Ordinance Section 110-807, subsection E, stock of trade, storage of stock and trade, shall be located within enclosed building and within space limitations in Section 110-807D. No product shall be displayed on the premises. No toxic, hazardous material shall be stored on the premises. Corrective action for said violation is to remove all stock and commodities from the residential dwelling, which is the dumpsters. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. These cases was initiated by a complaint on June 9th for commercial dumpsters being stored on the residential property. On June 10th, a notice of violation was issued for vehicles damaging the city's right-of-way, which is violation A, driving through the city's right-of-way, which is violation B, and storing commercial dumpsters on the residential property, which is violation C. The notices were given to the wife of the property owner, who then called her husband. They both were upset about the violation, stating they was told at one point the dumpsters can be at the property. Notice of hearing was posted on September 11th, 2025. As of today, all 3 violations remain on the property. The city would like to request 30 days for the property to come into compliance, or a fine of $25 per day for each violation to be opposed until such time that the property owner notifies the city of compliance.
Thank you. Sir, can you state your name and address for the record?
Hi, Your Honor. My name is Jose Pereira, and I'm the owner of 1018 Giovanni Street, Deltona, Florida.
Okay. What would you like to tell me about the case?
All right, I got a picture right here that didn't show on there. Someone's young sent a text to somebody saying that he's been dealing with me for 3 years already, and I'm still getting away with this. He says 3 years because before this, all the pictures are from like 3 months ago. It wasn't from before. But before this, they were saying that I wasn't allowed to have a dumpster on the property because of the agreement that you guys have with Waste Pro, that I'm not allowed to have a roll-off dumpster. Well, if it's a trailer, a dump trailer was okay. Which all those pictures are from 3 months ago, and as you can see, the right-of-way from the picture that they took today, it looks a lot nicer. So I tried to fix it, but the dumpster, the trailer that you see back there, because I'm cleaning up my backyard. So which they say that I have to call Waste Pro and order a dumpster from them, which is gonna cost me $500. Why would I rent a dumpster from Waste Pro to clean my backyard and pay $500 when I can use my own dump trailer and pay $35 a ton? But it's gonna cost me less than $100.
Well, these are your dumpsters?
Yes, they are mine.
Are they for your business?
Well, I closed the business on last year on December. But I kept some of the dumpster. I still have like 5 or 6.
Okay, so you own them?
I own them. They are even the trailer and the truck. They didn't show in the picture, but it's right here from the 9/11. That was because I was picking up my son from BPK, and I left the truck on the side of my house. I haven't parked a single dumpster on my truck on my house for those 3 months. That was the last warning that I got on those 6/9. That was the last warning that I got. And I stopped doing the dumpsters because they say they were going to charge me $250 if I keep doing it, which I stopped doing. And then I stopped doing it, and the picture with the truck that they didn't show on the paper, if you want, I can give it to you.
No, I have it in the file.
All right.
Yeah, I see it.
I was picking up my son. The VPK is 2 minutes from my house. So my yard is in Orlando. It doesn't make any sense for me to drive to Orlando to leave my truck because I was working on Dillon, leave a truck, then come back to Deltona, and it was less than maybe 1 hour.
Let me just pause right there. The violations that are being alleged are not about the truck. Am I right, City? Right. Yes. So I understand that I mean, it's in the file, but the violations are not about parking the truck there for a few minutes.
It's
Obviously,
about
you're not
the
supposed
truck,
to.
It's about the trailer, the dumpsters.
It's about the
dumpster.
dumpster.
The right-of-way.
And the right-of-way.
Yes, which, as you can see, but how would I get to my backyard if I cannot use the right of way? So do I have to drive from the driveway that is on the other side of the house?
Okay,
Through the whole front yard to put the trailer there to load my trash?
So let's take the violations one at a time.
Yes.
The first one is about maintaining the right-of-way and making sure that it's litter, debris is removed, cutting the grass and weeds, and maintaining a neat and trim appearance. There's clearly, okay, so B2, I can see there's more grass that's been basically removed due to
the one from
driving.
today?
And B3 is a little bit better. Today, perhaps a little bit better, but not fully there. There's
If
still,
you check any house on Deltona, they don't have like fully grass around the house. It's sand. So it's hard, even if you put seed, you can buy new grass from Home Depot, it dies. Most of it doesn't stay there because my whole yard doesn't look that nice. So you have sand. It's not like you have dirt. It isn't good for the
you're
seed.
saying that you have tried to plant grass?
Yes, I
and
have.
to-
Well, you see a difference between that, from 3 months ago and now.
Yeah.
I've been trying to do my best to
Okay.
keep it up.
I'll let the city respond to that. What is your response to, there has been obviously some effort to repair or restore the right-of-way. That's apparent from the photos, so.
I was advised to bring them to the magistrate, so.
Well,
Since these vehicles are still going through the right of which we don't allow, he is continuing, not properly maintaining that right of way.
well,
excuse
okay,
me.
but so you're jumping forward to violation B. So right now I'm on violation A, which is the right-of-way maintained properly? And it obviously looks like there's been an effort to.
It's not
to restore it.
100%. Like, I won't lie to you. I drive through there sometimes. But it looks a lot different from 3 months ago.
Yeah,
3 months
that's
ago
apparent
was
from the
like
photos.
ugly. Now at least I'll say it's like at least 80% done.
All right.
It's just some parts that in its grass.
Yeah. All right. Let's pause this one. I want to talk about violations B and C. So for the city, I have concerns about both of these. So violation B is for, that you're using the right-of-way for a basically non-intended purpose without prior written consent of the city,
Yes,
which would be the city commission.
correct.
The right-of-way, the intent for a right-of-way is for a thoroughfare. So what would I be finding that is, what is the unintended purpose? What a right-of-way is intended to be used for as a thoroughfare?
It's not allowed to be used as a thoroughfare unless there's a permit issued for that. And when they, for access to the property other than the driveway, we require an apron, concrete apron, to cover that area. That way, the right-of-way is properly being maintained. But in this case, he is not. He's tearing up the right-of-way with commercial vehicles and the trailers going in and out of the property. The city does not want that to happen. We want to maintain the right-of-way. And there's no permit application submitted for that, access to the right-of-way.
Is there a separate code section that establishes that you need to have a permit for driveway access?
Excuse me, I was never informed of that. They just told me I couldn't do it. They never told me that you could get a permit to drive through here. I was never informed of that. I was just told that you cannot use the right of way. That's what it says on every citation that I got at my house.
All right. And sometimes, depending on what the code says, you may not be able to obtain a permit for it because you can't have more than a certain number of openings or driveways, within a certain distance. Again, I don't know, but I'm struggling to find that this is not an intended purpose without some additional backup information, like that there's another code section that says you must have a permit for driveway access. If you can point me to that, then I would consider that.
In this case, we just don't want him to use in the right-of-way to access the property.
Well, again, I need to have a code section to help me say what is the intended purpose, because I think if you understand what I'm saying is that a right-of-way, that's the nature of the right-of-way, is that it is supposed to be used for a thoroughfare. So I need to have some additional evidence of intent that the city commission does not intend for it to be used in this way. So where is that in the code?
Okay.
That's what I'm asking.
Okay.
I'm going to talk about violation C for a moment, too. This is citing a home occupation section. So the gentleman has said that he is not running a business from the house. What evidence does the city have that he's running a business from the house?
We see the dumpsters with his logo for the occupation, for his business, and we just checked Sunbiz. His business is active, according to Sunbiz right now.
It's not under my name or my address. And it's a different company. I sold the name to somebody else, and I kept some dumpsters. The Amazon dumpster used to be under YMP service. Amazon dumpster used to be a fictitious name that I paid for to run my business because I had a different name. And I didn't want to create another company and new credit and all of that. So I created Amazon dumpster to keep my old company, my old LLC, which was closed on last December. You can check on Sunbiz YMP Service LLC, and it was closed last December.
All right, so you are using them for your business purposes?
Not right now.
Dumpsters?
Not right now.
They're for your personal use?
Yeah. When they're in my house, they're for my personal use.
Okay. If there's a factual issue there in terms of whether or not he's using it for business purpose. Also, I'll note that this section of the code, 110-807, it hasn't been updated since 2013, and there have been, there's the new state law about home-based businesses. And I'm not sure, have you conferred with the city attorney about this section?
We have not, for this case. We'd like
Okay.
to, so
I think because, again, there's certain preemption issues that arise with that home-based business section, and I question
gotcha.
this one. So I would suggest to you that you, at minimum, may want to continue violation C to discuss that, whether you want to pursue that.
Actually, I'm going to continue all three.
Okay?
That way we can, review with our attorney, city attorney on these matters.
Okay.
Okay?
We will do that.
Thank you.
All right, we're going to continue the case, sir, to next month. So in the meantime, I suggest you try to maybe speak with Mr. Ron, see if you all can come to a resolution so you don't have to see you back here, I hope.
Here's the thing. They tried to get me for a while because I wasn't allowed to rent dumpsters on Deltona. So this been going on for a couple years already. When they couldn't get me because I wasn't renting on Deltona, I was just putting the dumpster on my house. Well, I was like slow or I didn't have enough work. I was just storing the dumpster on my house. They were saying that I was renting the dumpster. I explained to them. Every time they send a different person. This is the first time that I see him. Nobody that I have go to my house, I have seen him before. It's in here. Every person that went to my house except him. I think he was on my house the 12th, and he saw my dumpster was on my trailer, and I was cleaning on my backyard when they went to my house. So the house is not used for commercial use. I just touch sometimes the dump, and most of the time it's not even 24 hours. Most of the time, if the day's low, I just leave it there, and the next day it's gone.
All right. Let me just say, first of all, we're going to continue the matter. I would just caution everyone that I'm questioning some of the citations here. However, I believe that there are other sections of the code that would prohibit you from having dumpsters in your side yard, okay? So whether or not they have, whether or not these particular citations are proper, we'll determine that next month, but there may be additional provisions in the code that would prohibit you from having commercial dumpsters, whether or not you're using them for personal use in your side yard. So I'm strongly encouraging you to try to work with Mr. Ron and resolve the issue, so I don't have to see you back here. Okay?
Yes, ma'am.
All right.
All right.
Thank you.
Thank you.
Mm-hmm. All right, this is DEL 25-066, Massey case, 3259 Shingler Terrace.
Hi.
Oh, no. Go ahead.
Thank you. My name is Janice Polasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be Massey case number DEL 25-066, the City of Deltona versus Vivian Jimenez. The property address is 3259 Shingler Terrace. The parcel ID number is 813-047-020-240. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on July 23, 2025, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 a day since August 22, 2025. As of today, the property has accrued a total fine of $850 over 34 days. The city is requesting that the fines continue at $25 per day.
Thank you. Okay, so this is a picture from
This is
today.
for yes, the soffit is still not repaired on the side of the garage.
Thank you. Soffit is essentially missing.
Yes.
All right. I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance. And an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm going to admit the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Thank you. All right, the next case is DEL 25-089, 1556 East Normandy Boulevard. Oh, okay. Yes. All right, Fire 037-2025, A, B, and C, 1200 Deltona Boulevard.
Your Honor?
Yes.
This case came into compliance just shortly before this hearing.
Oh, okay. All right, so that one is withdrawn. Let me write that down, actually. Okay. We have Fire 038, 2025, A through F, 605 Cortland Boulevard.
Good evening, Your Honor.
Good evening.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This case will be Fire-038-2025, City of Deltona versus MFP Deltona LLC. Property address is 605 Cortland Boulevard, Deltona, Florida 32738. Parcel ID is 8136-03000010. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal for the following violations.
Ms. Nadeau, sorry to interrupt really quickly, but so the agenda says A through E, and the case file says A through F. Is there an F, violation F? No, it's just a mistake on the file. Okay, got it. Thank you.
Yep, you're good. Violation A, NFPA 1, Chapter 13.1.6, detailed records documenting all systems and equipment testing and maintenance shall be kept by the property owner and shall be made available upon request for review by the AHJ. Violation B has come into compliance prior to this hearing. Violation C is NFPA 1, Chapter 63.2.1.12.2.2. Signs prohibiting or open flames within 25 feet of area perimeters shall be provided in areas where toxic, highly toxic, corrosive, unstable, reactive, flammable, oxidizing, or pyrophoric gases are produced, stored, or used. Violation D has come into compliance prior to this hearing.
Okay.
Violation E is NFPA 1, Chapter 13.1.8. All fire protection systems and devices shall be maintained in a reliable operating condition and shall be replaced or repaired where defective or recalled. Corrective action for the said violations is Violation A. Please provide a copy of the current backflow inspection maintenance report for the Cortland Boulevard entrance. Violation C, please provide signage on the LP tank which states no smoking. And violation E, please contact your fire alarm service provider to repair the deficiencies outlined in the 12/03/2024 fire alarm inspection report. Statutory requirements for this notification of this hearing have been made or have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 26, 2025, I conducted a fire safety inspection at this address where I observed that the above-mentioned violations. The property owner was notified in writing of the violations and given a time frame to correct said violations. Subsequent re-inspections on May 9th, 2025, June 4th, 2025, June 26th, 2025, July 17th, 2025, and August 20th, 2025, found no progress on the noted violations. The city would like to request 30 days for the property to come into compliance with the remainder of the violations, or a fine of $50 per day per violation until such time that the property owner has notified the city of compliance.
Okay, so so we're talking about violations A, C, and E, correct?
Yes, ma'am.
So violation A, you are requesting the backflow inspection and maintenance report?
Yes, from that tag.
Okay, so there was an inspection and the tag said that is the tag saying there's deficiencies?
No, it's a green tag, so it shows that there's no deficiencies.
Okay.
But we just need record of Yes.
Okay. Okay. And then for violation C, this is, is there a picture for that?
Yes. See how the propane tank and has no smoking signs on it.
Okay. And what is the property used for?
It's retail, it's Publix is the main store, and then there's a retail side to it.
Oh, okay. So it's like a shopping center?
Yes, ma'am.
Okay. All right, and then for violation E, so the violation is that they are not maintaining the fire protection systems basically in a good working condition, right?
Yes, specifically the fire alarm.
Okay, the fire alarm, did you inspect that?
I was able to gain access to the closet one day and saw the tag on there. They did send me the report, and there was noted deficiencies, and I'm just asking for a report showing that those deficiencies have been repaired.
But you were not able to yourself determine that there was a deficiency?
I'm not certified to do the fire alarm systems. I'm not.
Yeah. Here's my problem is that without that, without your inspection and your personal knowledge, then I'm basing it on hearsay, which is a report from another person.
From their fire alarm company that maintains the fire alarm panel.
Right, but that's still hearsay. I saw that your light came on, Mr. Schaller.
I mean, I disagree, Your Honor. The fire alarm contractor's, licensed contractor by, Florida Department of Business Professional Regulations. They certify that the alarm system is either currently still in compliance with NFPA 72. They test all the devices. If it is, they provide, a clean bill of health report. If it's not, they provide a report on the bottom of it has deficiencies. They do sign their name of who inspected the system. They provide their state-issued license number. They're either a specialty fire alarm contractor or a general electrician. And this is, it's been an industry norm in fire prevention for fire alarms came around, I want to say in the early 60s, electronic fire alarms. And that's been the norm that has been held, is that if the fire alarm contractor cites a deficiency.
Yeah. But, I understand that. The problem, though, is that I'm not permitted to find a violation based solely on hearsay. And the violation here is based solely on a report by someone else that obviously that person is not present. And so I have no one here that has really personal knowledge of the fact that the fire alarm system is not functioning properly. So, as much as I'm concerned about it from a safety standpoint, of course, but I feel that I'm not able to find a violation based solely on hearsay. So, for that one, I think I'm going to I can continue it if you think that you might be able to have the person who has actually inspected it provide some testimony, or if Ms. Nadeau, you said that you weren't licensed to do that, but, if there's someone else with the city who's able to do that, if you would like me to continue it, I can. That's up to you. But I don't feel that I can find this violation based on the evidence that's been given.
Is that different from, I know previous cases, we have presented these reports and you have found a violation based on them?
Well, I think that, I don't see, I don't see how this is anything other than hearsay. And there's nothing, usually you have pictures, you have other things that are, I think, supporting your testimony. Again, I can find violations where there's other competent and substantial evidence to support it. But in this case, all I have is your, testimony that there's a report that says there were deficiencies, and that is hearsay. So I don't think I can, yeah.
No, I didn't mean to interrupt you. I'm sorry. I apologize.
No, go ahead.
Do you have a copy of the report in your exhibit packet?
I may, but it still would be hearsay, even if it's in the packet.
I think what I was trying to get at is in the report, and I'm gonna join Miss Nadeau there so I can take a look at the report myself.
Is it this page right here, page A? Or
It would be Exhibit H, as in
H.
hotel. Exhibit H, go to the last page, and then under Section 7 deficiencies, it's two 12-volt, 8-amp-hour batteries testing low need replaced. And then there's one 12-volt, 8-amp battery in a monitoring box testing low, which needs replaced. It would be impossible to take a picture of the battery testing low.
Well, again, my offered or suggestion is, if you want to continue it and you can have someone who has firsthand knowledge to testify, then that is your option. Otherwise, I can dismiss violation E.
All
That's
right,
up
we'll
to
go ahead
you.
and continue violation E.
All right. All right, so we're going to continue violation E. Okay. Is there anything else before I make the ruling?
No, ma'am.
Okay. And I'm sorry, you suggested that you would want them to come into compliance for A and C by when?
30 days.
30 days? And are you requesting $50 for each or $25?
$50 per day per violation.
Okay. I'm going to find respondent in this case in violation of the city code as charged for violations A and C, and that respondent correct the violation before 4:00 p.m. on October 24th, 2025, which is 30 days. And in the event respondent does not comply by the state, a fine in the amount of $50 per day for each violation, which would be $100 total, will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm going to admit the case file and PowerPoint as exhibits, and I find the notices properly given in this case. And again, we will continue violation E to next month.
Thank you.
All right, thank you. This is Fire 039-2025, 1878 Providence Boulevard.
For the record, my name is Samuel Schaller, employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 36-2025, City of Deltona versus Fast Lane 1878 Investments, Inc. Property address is 1878 Providence Boulevard, Suite T, Deltona, Florida 32725. Parcel ID is 813-015-160-060. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, Fire Code, Chapter 1.7.12.10, which states no construction work shall proceed till the proper permits have been achieved. Until the proper permits have been issued by the authority having jurisdiction. Corrective action for said violations is to obtain an issued building permit for the new wall and door. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property owner's records, property appraiser's records, excuse me. You know, Your Honor, I'm going to have to completely back up.
Okay.
Going to have to continue this case as well. My printer printed me all the wrong information for this case.
Okay, all right. So we're going to continue 039. We had a lot of continuances today. All right. Is that the last case? Oh, okay, all right. Anything else that we need to cover before we adjourn? No? All right. We are adjourned. Thank you.